Your attorney, Mr. Burbank, characterized your actions that day as, quote, and I wrote it down, kind of stupid. I think I would beg to differ with that. Shooting a vehicle no less than 6 times as it's moving down the highway. Let me ask you this. Did you know if there was a baby, a child, a kid in the backseat of that Suburban when you fired off 6 shots at it? Did you know if there were?
No, sir.
Could have been, could have.
Yes, sir.
You could have killed a kid as well, in addition to shooting Hunter Freeman, right?
Nah, that's me.
This is not how this works. Your attorney can ask you follow-up questions if he chooses to. But
Yes,
you could have killed a kid that day, in addition to shooting Hunter Freeman, right?
yes, sir.
Those bullets could have ricocheted off or went through that Suburban and hit oncoming traffic. Wouldn't you agree?
Yes, sir.
Hunter Freeman could have become incapacitated, lost consciousness, and veered into oncoming traffic or hit another vehicle. Wouldn't you agree? Yes or no? Wouldn't you agree?
Yes, sir.
Okay, again, working there back on March the 21st of 2026.
I was.
And at around 12:30, what, if anything, caught your attention? And I want to be careful not to get into hearsay. In other words, what someone other than the defendant said. So, but describe to the jury what caught your attention.
I was advised by my fellow officers that an inmate was refusing to go back into the holding cells at the recreation yard.
Can you stop there right there? Did you make contact with that individual, that inmate that was refusing to go back into the holding cell?
I did.
And again, I don't want to get into what he told you because it's hearsay. But as a result of what he told you, did you then go and pull Asa Jones out of his cell?
I did.
And did you bring Asa Jones back to your office?
Yes, sir, I did.
And did you speak with Asa Jones about whatever issue it was that the other inmate had, which was causing him not to want to go back to his cell?
Yes, sir, I did.
Now, you certainly can say what the defendant told you. That's not hearsay. So at that point, what did the defendant tell you?
That he admitted that he had thrown a substance on Mr. Franklin.
A substance believed to be what?
To be urine.
Okay. And unfortunately, is that a common or uncommon occurrence out there at the jail?
It is a very common occurrence.
Is there like a term that's referred to that?
Dashing.
Dashing.
Yes, sir.
It's not uncommon for inmates to dash other inmates, and it's not uncommon for the inmates, unfortunately, to dash correction officers. Correct?
Yes, sir.
To dash a correction officer, that is it's a felony, if not mistaken, right?
Yes, sir.
And that's not limited to just urine, unfortunately, right?
No, sir.
Other bodily things, correct?
Yes, sir.
All right, but with regard to other inmates, at a minimum, is that a violation of the jail rules or guidelines out there at the jail, right?
Yes, sir.
Something for which the defendant would have known or defendants are advised is not allowed or not appropriate, right?
Yes, sir.
The fingerprint again was a good quality to be able to make the comparison to the known print.
Yeah.
As well as the name and the date of birth on the.
In what ways does this, what happened to you, affect you and your life?
It's hard to sleep sometimes. Constantly remember there's been shots and everything. You're hearing in my ears at least 3 or 4 times a day. I can't hear out of my left ear damn near at all. I still do have clear hearing, but it's muffled. You can just tell the difference between your left and right side. My teeth, they tell me I can never have a full set of teeth again, most likely. Not unless they do some side of more surgeries, and it's just it's still hard to eat sometimes. Can't eat certain things, whatever, just because of how sensitive everything is.
You understand this jury's task with assessing what they consider to be the appropriate punishment for this defendant for what he did to you. You understand that?
Yes, sir.
You understand they've got a really wide range to choose from, anywhere from letting this defendant walk out of this courtroom with a piece of paper and promises what they call probation, all the way up to 99 years of life in prison. You understand that's That's on the menu for this jury, correct?
Yes, sir.
Have you given some thought as to what you think justice would be and what you would ask this jury to assess in the way of punishment?
Yes, sir.
And what would that be?
Be 40 years, sir.
You don't reach that, or you didn't reach that conclusion lightly, did you?
No, sir, not really.
You gave it some thought?
Yes, sir.
Why do you say 40 years?
I don't want him to go to life forever. I don't want him to be in prison forever. Everyone makes mistakes, sir. I do understand that. But also what he did was wrong. And I just don't think he should be able to walk away from it either.
I mean, you've got to live with those memories for the rest of your life, right?
Yes, sir.
You've got to live with your hearing loss for the rest of your life, right?
Yes, sir.
And you've got to live with the issues with your.
Let me ask some questions.
Go ahead, sir.
Mr. Freeman, if you were sitting there and Asa was sitting there and Asa was asked, what do you think the appropriate punishment might be? Okay. And Asa said 40 years. Okay, 40 years. How old are you?
23.
63 years old. And this is based on testimony yesterday from you that said, I caused it, right? You testified to that. So you have to answer.
Yes, sir.
I taunted him. Remember
Yes, sir.
saying that? I said, come on, do it.
He couldn't have heard that statement, though, but yes, sir.
But you said that,
Yes, sir.
okay? And you said, I wasn't going to back down because that's how I wasn't taught.
But I did back down, sir.
No, but did you testify to that?
Yes, sir.
Okay. And so with that being said, and that belief, 40 years,
Yes, sir.
another individual that did that and said that, which was you, and he reacted to it.
Yes, sir.
Nothing further.
Mr. Coleman,
Hunter, are you on trial here today?
Yes, sir.
Sir,
Yes, sir.
Asa Jones is on trial for shooting you in the face, right?
Yes, sir.
Could you in any way on God's green earth have envisioned that when, regardless of how that road rage began or started, or who cut who off first, is there any way you could have envisioned that this defendant would pull out a gun and shoot you in the face?
No, sir, because I had one on me myself and I did not even think of even reaching for it.
Thank you. I'll pass.
Two last questions. This started approximately 2 to 3 miles before an actual shooting. That's what the testimony indicates, right?
Yes, sir.
So for 2 or 3 miles, you had a chance not to cause it, not to taunt him.
So did he, sir.
Okay. Not to taunt him. And not to just stay there because no one was gonna do that to you. Right?
Yes, sir.
I have nothing for them, Judge.
You know that this jury now has convicted your son of aggravated assault.
Yes,
In
sir.
reference to the incident happened on East Texas Freeway. They now have to try to determine what punishment might be appropriate. You
Yes, sir.
understand that? Now's our time to kind of talk about Asa. Okay, how many other children do you have?
4,
Okay, and how old are they?
31, 30, Asa 27, 25, and 22.
And did they all live together at one time?
They all grew up together. I was a single mother.
And fathers, was Asa's dad around?
No, sir.
Where was Asa's dad? Do
No
you know?
clue. No clue.
No clue. Never had anything to do with him.
No, sir.
Did he ever have a father figure in his life that he could rely upon like a dad?
Well, I have several brothers.
Okay. Some of your brothers, did they go to the penitentiary?
Yes,
So maybe not very good role models.
correct.
Okay. What part of town did you grow or did you reside in?
The North End,
North End.
yes, sir.
And we had testimony from a police officer here that knew Asa in school. What elementary school and middle school did he go to?
French, Caldwood, French and Caldwood.
Okay. And then middle school, is that
Austin and Vincent.
okay? After he finished middle school, what high school did he go to?
Central.
Central. Somewhere in Central, did he graduate?
No, sir.
How far did he get in school?
The 10th grade.
Okay. He was still living with you.
Yes, sir.
When he dropped out of school, did he just sit around or did he get a job?
Oh, no, he always had a job.
Okay, and tell us what type of work that he did.
Well, from maybe 15 to about 23, maybe, he worked at a convenience store. It was a family-owned convenience store.
Okay,
And then he worked at Popeyes. He worked at Focus, which was like a call center or something.
is that the one on Lucas?
Yes, sir.
That the old Lucas and
Concord, yes, sir.
okay. I worked there. Okay, so he always had some type of trying to make a living.
Yes, sir.
With his money, did he help out with the
Oh,
house?
very free-hearted. We wouldn't have on bills. Or if I told him that a bill needed to be paid, he paid it because I was at work as well.
Did he get along with his siblings?
Oh, very close.
He hasn't been perfect. He had some run-ins with the law with misdemeanors, some guns and this and that. Did Asa ever have an incident where he had been shot?
Yes,
Okay. And when he got shot, was it at his house?
yes.
And was he doing anything wrong or was he just shot?
Well, not to my knowledge, he wasn't doing anything wrong,
Okay,
but the house, I don't know if it was, I'm not really sure what happened in the situation, but the house did get shot up and he was hit with, I think, 2 bullets.
okay. Just kind of like standing around.
Yeah. Well, no, actually, he was in the bed. It happened at 4 in the morning.
So he was in his own bed.
Yes.
And did that affect him?
I'm sure.
Do you think he got hit with 2 bullets?
Mhm.
How long ago was that?
2020, I want to say.
2020.
Yes, sir.
Okay.
Would you want the person that shot your son Asa in the face to get probation?
Maybe.
You can envision the situation where if they shot him in the face, that you would be okay with them getting probation, yes or no, Ms. Spencer?
Yes.
Okay. Did you know if there was a baby, a child, a kid in the backseat of that Suburban when you fired off 6 shots at it? Did you know if there were?
No, sir.
Could have been, could have.
Yes, sir.
You could have killed a kid as well, in addition to shooting Hunter Freeman, right?
May I speak?
This is not how this works. Your attorney can ask you follow-up questions if he chooses to.
Yes,
But you could have killed a kid that day, in addition to shooting Hunter Freeman, right?
yes, sir.
Those bullets could have ricocheted off or went through that Suburban and hit oncoming traffic. Wouldn't you agree?
Yes, sir.
Hunter Freeman could have become incapacitated, lost consciousness, and veered into oncoming traffic or hit another vehicle. Wouldn't you agree? Yes or no? Wouldn't you agree?
Yes, sir.
Okay. Again, Mr. Burbank can ask you all the follow-up questions he wants to ask you.
Yeah, I'm going to object to the sidebar remark.
Overruled, go ahead.
You asked for a second chance, your words. But you would agree with me that you've already had a second chance. In fact, you've had a third chance when you received that first probation and the second probation. Wouldn't you agree?
May I?
Yes or no? You've had at least 2 prior chances before coming in here asking this jury for probation. Yes or no?
Yes, but not a violent.
Excuse me, non-responsive judge. You are not asked the judge.
Just answer the question. You're,
Can I say?
this,
one thing?
no. This is how it works. Mr. Burbank can get up in just a minute and follow up on any of these questions with any explanations, okay? It'll just be easier if you answer it how it is. Mr. Burbank can stand back up and ask you questions, okay?
You understand those are the rules of court, right?
What's the rules?
What,
Just ask questions.
That's my question.
Yes.
You understand my
Now,
question?
ask a question that has to do with
Well,
this.
I'm gonna tie in, just give me one more
Okay.
question, I'll tie in.
Go
You
ahead.
understand, those are the rules of this
Yes,
court,
sir.
right? And you understand that there were rules in the jail that you had to follow too, is right?
Yes, sir.
Did you follow the rules in jail?
I did.
By throwing urine on another inmate, that you didn't break the rules?
It wasn't urine.
Yes or no? By throwing it, well, let me ask, okay, even if it wasn't, by throwing another substance on another inmate.
I got
was that-
gas first.
Listen. Mr. Jones,
I'm not justifying my answer, I'm just saying, he asked me
Listen.
a question that comes with his explanation, like, it's a
You're-
yes or no.
listen. Listen to the rules. Again, right now in court, listen to the rules. The rules are answer his question. If there's an explanation, your attorney can stand up, ask you for an explanation, and you can give that explanation. That's the third time I've told you,
Yes.
yesterday and now today twice.
Thank you. You didn't follow the rules regardless of what you threw on that other inmate, did you?
I follow the rules in jail.
And that's what you want this jury to believe.
I do.
Okay. You also said that you've learned and reflected on your mistakes. Is that what you want this jury to believe?
Yes, I do.
And this jury will make the determination as to whether or not you can follow the rules. Because probation, you would agree with me, has rules, right?
Yes, sir.
And you violated the rules of your most recent probation by committing aggravated assault, correct?
Yes, sir.
That's the witness, Your Honor.
Thank you, Mr. Burbank.
Mr. Burbank, ladies and gentlemen of the jury, I want to begin like I began during the guilty innocence phase, where I gave my closing remarks by thanking you all for your time, thanking you for your attention. And I want to say that when I first heard about this offense, I heard about it on the news. I vividly remember it back in June, on June 12th of 2025, watching it on the news, and it offended me deeply. It very deeply offended me that someone over something so stupid and trivial as being cut off would shoot somebody in the face. And when this case landed on my desk and I started to review the case and the reports, I remained offended that not only that this was a criminal offense, it offended the penal code, but it offended my sense of human decency. It offended my sensibilities as a member of this community, because it shouldn't be this way. It should not be this way. Mr. Burbank would draw a distinction and everything. This is not the typical gun violence crime that we're seeing in Jefferson County. I'll submit to you that it is. This is typical of someone who just has a dispute with somebody and instantly goes to the gun, resorts to the gun to settle that dispute. It doesn't have to be this way. It shouldn't be this way. And you can send a message via your verdict to say, we will not tolerate that anymore. This defendant has asked for a second chance, but you've heard testimony and evidence about the fact that he's had at least 2 previous probations. He violated his probation, the current probation, by committing this offense. You saw in that video, he was leaving the probation department. He just met with his probation officer before pulling out a gun and shooting somebody in the face. We had this back and forth discussion during jury selection about rehabilitation. Rehabilitation is great, but remember, it's one of those 3 goals of the criminal justice system. One of which is to punish, the other one is to deter. Punishment, deterrence, and rehabilitation. Rehabilitation only works if somebody's receptive to it, if somebody wants to be rehabilitated. 3 previous unlawful carrying of a weapon cases wasn't enough to rehabilitate this defendant. Okay, it would be nice if we can figure out what his malfunction is, what his defect is that makes him recidivate, that makes him revert back to crime. But that's not our job. Not my job, I'm a prosecutor. Not your job is to see that justice is done and render the proper verdict in this case. It would be nice to know that, but whatever it is, it's in his nature, ladies and gentlemen. And insanity is defined as doing the same thing over and over and expecting a different result. And if you put this defendant on paper, as they call it, and with the promises and conditions, to, I guess, I promise not to shoot somebody in the face again. That's all it is a promise. He made the same promise when he was on probation before. The same promise not to commit a crime. Ladies and gentlemen, that's offensive as well. It offends me that he would come in here after committing this offense and look you in the eye and ask for probation. There are cases that lend themselves to probation. There are situations and defendants and circumstances that lend themselves to probation. A DWI, first time DWI, somebody who evades from the police, they didn't want to pull over because they were scared. Something like that, some property crime or something like that. There are those cases that lend themselves to probation. But it is offensive to ask for it in this case under these circumstances. And I just can't believe that he would even come in here with a straight face and ask you to do that. Ladies and gentlemen, you've got a duty to protect this community, to protect this society. You may not think that what you do in the way of your verdict makes that big of a difference to protect our society, but think about this. Had he been in jail for that previous offense that he was on probation for, then Hunter Freeman may not have been shot in the face. If you let him walk out of this courtroom, who knows what, if anything, he will do. He just doesn't get the message, okay? You also have a duty to Hunter Freeman, a duty to render a just verdict. And when I say justice, I'm talking about equity, something that is fair and on par with the harm that he has suffered. Letting this defendant just walk out of this courtroom, having just been minorly inconvenienced, is not fair or equitable when compared to the harm that Hunter Freeman has suffered. You heard of the long-term effects, having to recall that event over and over, the loss of hearing, the loss of his teeth. That pales in comparison to probation. This defendant, let me say this, 3 weeks from now, you and I, we're gonna go on about our business. 3 months from now, you will struggle to remember the names of the participants in this trial. My name, Mr. Burbank's name. 3 years from now, this will be a distant memory for you, for all of you. But 3 years from now, Hunter Freeman will still be dealing with the consequences. He'll still be reliving this. He will still have the physical impairments from this offense. 3 years, 30 years from now. So I submit to you that putting him on probation is not on par. It's not equitable. It's not justice. So please, I implore you, don't do it. Do not put this defendant on probation. And when
We, the jury, having found the defendant, Asa Joseph Jones, guilty of the offense of aggravated assault, assesses punishment at imprisonment in the Texas Department of Criminal Justice for a term of 7 years and no fine. You can have a seat. Does either party wish to have the jury polled?
No, Judge.
No, Your Honor.
Right then, any reason not to pronounce judgment at this time?
No.
Stand.
Then at this time, Mr. Jones, in accordance with the jury's verdict, again, I've already found you guilty, and at this point, you're now sentenced in accordance with that verdict to a term of 7 years in the Institutional Division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.